I do see Mr. Anagnosio there. I believe the state is present. I'm guessing Ms. Powers today, if I'm not mistaken.
Probably Miss Looney.
Oh, there is Miss Looney. I didn't see Miss Looney log in at first. Okay. So Ms. Looney is on this. And then do I have the guardian on this case? Well, maybe I spoke too soon. Do I have Jill Marie Hicks? Well, maybe we'll give it just a couple minutes. I just have it on for a review. I'll come back to this one. So Mr. Anagnosio, we can take your other matter. I do believe Ms. Glenn's is online, the guardian Anna Lynn Glenn's. Mr. Anagnosio was just appointed at our last hearing just a couple weeks ago to mother. Oops, we've got a few more people coming in. I apologize. Just a second. Was just assigned to mother Kimberly Glenn's. We did send her the order appointing you, Mr. Anagnosio, but it got returned undeliverable to the court.
Right.
So maybe I'll first, go ahead.
Well, and the phone numbers that the court provided, they weren't correct. And so I talked with the petitioning party, Miss Glenn's, this morning, and I talked with Miss Day. My client is incarcerated up in Gig Harbor, and they thought maybe she might be here today. She had appeared at the last hearing, but I haven't had an opportunity to speak with her about the case.
Okay. And Ms. Anna Lynn Glenn's, anything for the court to know today?
Well, Ms. Day said that they were trying to find the father to serve him, but they cannot find him. So I don't know.
Okay.
What's going to happen today, actually.
Okay. Ms. Day, any input? I know when we were last here, we did have a brief discussion about the difficulty locating father.
Yes, so that difficulty continues. I talked with mother while she was still here locally, and she reached out to the connections that she had, and there's been no progress. Nobody has any indication where we might find him. So I don't know what our options would be, potentially serving him via instant message on Facebook. If he has a Facebook page that's active. That's about the only suggestion that I can make. In the meantime, mother has agreed with this emergency guardianship, and I think that should continue as we work through this process, but that's kind of where we are. I have finished my court visitor report, which I'll be filing with the court today, and I'll provide a copy to Mr. Anagnosio and petitioner. But that is really the end of my involvement unless the court wishes me to remain involved until father can be located.
Okay. Yeah, if you do you need additional, here's my thought, especially since mom is now sounds like incarcerated, not local. We don't anticipate her being here, and Mr. Anagnosio will want to talk to her. I appointed an attorney to her because she did consent, but at the last hearing I wasn't quite sure she understood that she didn't have to consent, that sort of thing. So I did think an attorney was appropriate. So my thought was just to extend the emergency order to a new date, come back on review. Hopefully we've had some contact between attorney and mother. Perhaps mother has electronic service ideas for father. And then at the next hearing, we would come back and issue an order authorizing electronic service.
Okay.
So maybe Ms. Day, if you still have time available on this case, we'll have you hang in for one more visit, or I can approve additional time.
No, I still have time available, and I'm happy to remain on and continue until we have the next hearing. I'll continue trying to reach out to father and monitor, the jail roster and things like that in case, there's that opportunity comes.
Okay. So Ms. Anna Lynn Glenn's, what I'm thinking is I will extend the emergency order through the date of our next hearing so we can do a little more fact finding on service issues and gives mother time to chat with her newly appointed lawyer. Does that work for you?
Yes, absolutely.
Okay. I'm thinking probably after the first of the year, because I know the last 2 weeks of December can be difficult for folks' schedules. Is there a date in January that works for the parties? A Tuesday at 10:30?
I'm available, Your Honor. Tuesday, the 2nd would be the only day I'm not available. We have another formal hearing on a guardianship then, but if we could do the 9th, I think that would make good sense.
Does January 9th at 10:30 work?
That works for me, yes.
And
That
we'll
works for me, Your Honor.
It does. Okay, great.
Yeah.
So after docket, I'll prepare that emergency order extending through January 9th. I will try and get the year correct, 2024, so it doesn't come back to me from the clerk's office. I've been making that mistake a few times. 2024 at 10:30. I believe Ms. Day is still on this case as well. I know Ms. Muldoon is present. I see her attorney, Mr. Gooday, with us. I see Ms. Redden. I understand that Ms. Muldoon's mother is present. And then in the pink shirt on iPhone, are you on this case also?
Yes, I'm Cassandra's mom.
Okay, great. Okay, so I guess maybe I will first ask Mr. Gooday and Ms. Redden. My notes from our last hearing on November 14th included that we were extending visitation to allow in-person visits. So I wanted to kind of first check in and see how that's going from the party's perspective. And then I did also make a note that perhaps we'd be moving on with an evidentiary hearing today, but that may depend on how we answer the first question and if parties are needing a little more time. So maybe I'll first turn to Mr. Gooday if he's able to hear the court.
Yes, good morning, Your Honor.
Okay.
I'm here.
Good morning. I know you have other dockets going on too. What do you have any input on visitation from your client's perspective?
I haven't spoken with my client since, so I'm not sure. I guess I might defer to her on how it's going.
Okay. Ms. Muldoon, what can you tell the court about how the in-person visits have been going since our last hearing?
Oh, they're amazing. I love spending the time with them, and the bonding is really awesome. The last couple times I took him home was a little rough, just because he didn't want to go home. But other than that, he loves coming over and being with mom, so it's awesome. Just rebuilding that bond, with him is amazing with me. So, and working with him,
And what's your sobriety timeline now?
Today will be 95 days.
Wow, congratulations.
Thank you, ma'am.
Okay. Ms. Redden, how is visitation going from your perspective?
What? Sorry, making
Nope,
sure we had it on.
You're good.
I think it's going good. Austin, I know, has been enjoying it and the stuff they've got to do. I know there's a little bit of misunderstanding as far as what you had said about grandma being present, but that was clarified to them, so I think that's good. For the most part, I think it's going good. I mean, I think it's good for both of them.
Okay. So I guess my question is, and Ms. Redden, this is your petition. Given 95 days of sobriety, things seem to be progressing well. And are you planning to continue to move forward with guardianship of Austin? Or I guess I'm trying to gauge whether we're going to a hearing on making you an emergency guardian or whether we think that may not be necessary given mom's progress.
I think 95 days is awesome for Bree. I think it's, a good start, but I don't think it's to the point where we should start looking at transitioning fully. I think with Austin and his behavior and all the help we're trying to get him, I think it would hurt Austin, to pull him right now. He's doing a lot better in school. He's not being as aggressive. I'm not having to get phone calls every day from him. We are working on counseling starting this Thursday to also help him, but also we are working with the school district on his behaviors to help him learn how to adjust without showing the anger and emotion. So they are working on an evaluation that they're going to be starting. And I think all of that is very important for what Austin needs. I would personally like to see Austin be with us at least through the year or the school year, and then summertime start transitioning so that he can get the help he needs. Medical appointments were doing well. We got his teeth work done and that went good. We've been working on catching him up on his shots. He still has a urology surgery in February and a neurology appointment coming up too. So,
Okay. Ms. Day, I guess any input on your perspective on where we're heading here?
Yes. So I did have a chance to do a drop-in visit with mom, and the visits are going well. Austin's doing very well with mom. Mom's got her 95 days clean. She's in compliance. I'm waiting for that in writing from her treatment center. We had a little bit of difficulty with that, but I don't have any question about her recovery. She continues to reside with the great-grandmother, and she has proffered and offered up her great-grandmother as the emergency guardian during this time, and feels like that's appropriate, that Austin should be home. But she is not trying to eliminate the petitioner. She recognizes their value and the effort that they put into helping Austin be successful. And I think that's very clear. Austin has these evaluations coming up with the school district as well as the medical. And I think those are all very important. It would be my suggestion today that we move forward with some overnights. The holidays are around the corner. So I think a couple of overnights as a start to see how that works, allow mom to get a little bit more time under her belt. And then that can then be looked at whether or not we should move a transition sooner. I think summer's probably too long. Austin is an emotional child and he loves his mom, but he also loves petitioner. And so some type of transition and overnights I think is good, but I don't think he can go 6 or 8 months. I think that he won't manage that emotionally. If mother continues to do well, we could then look at what I like to call a reverse schedule, is transitioning Austin into mom's care full-time, and he can have some overnights with the petitioner and maintain that relationship and that support and still have all of his needs met. That the more people that love and support him, the better he's going to be, and he's going to gain his mother, not lose the petitioner. And I really appreciate that mom has come to that understanding instead of being hurt and angry, which sometimes we see. She fully respects all the work that Cassandra has put in.
Yeah.
So I'm hopeful with some overnights. I think that's a good thing to start with, would be to start with like weekends, Friday to Sunday. School is going to be, well, he's in preschool, so I don't know if he won't be probably out of preschool during the winter break, but it should continue for Christmas so that she can have Monday Christmas with him, and come back in 30 days and see where we're at.
Yeah, and just for my recollection, I know we had talked about Ms. Muldoon's mother filing her own guardianship petition. Has that happened at this point yet?
It would be my grandmother.
Your
and-
grandmother, okay.
Yeah. And no, she hasn't. We just kind of wanted to see where Ms. Day feels that I'm best, where my situation is right now and Junior's situation. And just see how it goes with this rather than opening up a whole new case unless it's absolutely necessary. Then we'll go from there.
Okay. Well, here's going to be my thought, and then I'll have all of the parties respond with if they think this is workable. Instead of going forward with an evidentiary hearing today, because I think we are making progress. And, to be perfectly frank, my standard in a minor guardianship. So, if this was a family law case and the petitioner and the respondent were divorcing each other and coming up with a parenting plan, my goal is to determine what's in the best interest of the child and make a parenting plan that effectuates that. In a minor guardianship case, it's much more limited. I'm looking at, is there a parent willing and able to take on parental functions? And so, Ms. Redden, obviously your burden is a lot higher in that regard for a minor guardianship, because it's not just what is in Austin's best interest. I would have to find that Ms. Muldoon is unable and or unwilling to undertake parental functions as defined by statute. So I would say, absent some further hiccups, I guess I would be surprised to see this last, until summer. I agree with Ms. Day that does seem pretty lengthy. I do agree with Ms. Day's recommendation to extend the immediate order. So Ms. Redden is still right now the emergency guardian, but then extend visitation to weekends with Ms. Muldoon at her grandmother's house. So the minor's great grandmother. I think I have that right now.
Yeah.
And so we'd be doing Friday to Sundays with Ms. Muldoon. With great grandmother present per the prior structure. I am going to add that Monday Christmas and Monday New Year's, if Ms. Muldoon doesn't have other obligations, that those two holidays would remain with her. So those two holiday weekends would be Friday to Monday. And then come back in 30 days, assess where we're at. At that point, Ms. Muldoon is going to have well over, fingers crossed, and I believe in you, well over 100 days of sobriety. And then if a party wants to push for an evidentiary hearing, we can. I'm just throwing it out there that, the burden of proof is whether Ms. Muldoon is able and willing to undertake parental functions, not necessarily do I think Austin's needs are better met with Ms. Redden versus Ms. Muldoon. That's not the criteria the legislature has set out for minor guardianships. So it is a bit of a balancing act. And I think what we're doing here today strikes a balance given Ms. Muldoon's great progress, Ms. Redden, your amazing ability to take this on while Ms. Muldoon gets better, does all the right things, and the two of you working together. I mean, we, like Ms. Day said, we don't see this very often on this docket. So kudos to both of you.
Your Honor, if I could just add, there was some, as Ms. Redden indicated, some miscommunication or misunderstanding, and many of mom's visits have not been with grandma present. Grandma's monitoring them, provides the transportation, but she's not always been physically present. And I don't think that that's necessary to continue. I think that was an honest mistake, that there was some misunderstanding about how that was supposed to be effectuated.
Okay.
I do think that it should be that mom has to be at grandma's house overnight. She can't stay the night at other people's homes, but I think there's no reason that she can't continue to participate in her sober community as she has been, and doing clean and sober functions. And Austin is often present for some of those things, as well as other family members. So I think that being monitored by grandma is more than appropriate. I trust that grandma will let me know if there's any concern or question going forward, but I think that that's appropriate in this setting.
Okay. I appreciate that input. Ms. Redden, any concerns? It sounds like the GAL's recommendation would be certainly overnights need to be at great-grandmother's home, minor's great-grandmother's home. But that there can be periods of time where Ms. Muldoon is alone with Austin for various outings and that sort of thing.
No, I don't have concerns with Bree having him out and about. I think now that she's clean, she understands what's safe and what's not for him. I hope, and that as long as, he's staying and sleeping at grandma's house, I don't see a problem. I would try to ask if they could keep somewhat similar to our sleeping schedules. So, we try to have him in bed around 8:00, just to keep that pattern going for him.
Yeah. And I see her taking notes and nodding her head. So I feel like that is going to happen.
He is an
Okay.
early bird, but he definitely needs that sleep, and we try to keep him on that schedule of, hey, we brush our teeth, we go to the bathroom, we read a book, and it's bedtime, and then that way it will make it easier for all of us, for her knowing that that's what we do when we go to bed, and then when he comes home, it's not an issue for him to transfer back and forth between us.
Okay. Great. Well, I'll definitely craft an order with those parameters. Do you all want to come back, and Mr. Gooday, I'll have you chime in here too with your availability. I could offer Tuesday, January 9th or Tuesday, January 16th.
I do have a question. If you guys are wanting me to continue with his evaluation for his IEP through the school district, I know Tina said that it would be really good. His full evaluation won't be done until the end of January.
Okay. I would go ahead and continue with that, and then we can assess where we're at kind of mid-January, right before that. But yeah, I mean, I don't see, well, we can address that further at the January hearing, but I would say go ahead with that for now.
Yes, and I think that makes good sense. It will transfer to a new school district if he's transitioning home at that point. But,
Okay.
and that is something that maybe even the petitioner mom can work with together and provide input so that there's kind of a smooth transition handoff if we're at that place when we get there.
Great. Mr. Gooday, did one of those dates work better for you than the other, 9th or 16th?
No, Your Honor, either one will work fine for me.
Okay. Ms. Day, any preference?
No, either is fine with me. I'm already going to be there on the 9th, so maybe the 9th would
Okay.
be a better date.
Let's do that. Let's take January 9th, 10:30 a.m. I'll just let the parties know, for 2024, I won't be the judicial officer on this docket. So I will try to leave very detailed notes for whoever is handling your January 9th docket, so they know kind of what we're working towards. I mean, it should be in the clerk's notes, but I think this has been kind of an exceptional case that hasn't followed our normal minor guardianship cases, and you both have worked so well together. So I'll do my best to keep the next judicial officer informed about where we've been and where we think we're going. Okay.
Thank you, Your Honor.
All right.
Thank you.
Thank you all.
I do have a question.
Yeah, go ahead.
We're talking Monday through Friday visits, right? What are the times?
So we're doing weekends, Friday through Sunday.
Yeah, so like drop off, coming home, like what? We didn't talk about a time.
Okay, let me pull up our last order. Did we set a time for our
It was from
visits?
10 to 3:30
Okay.
for Saturdays.
Oh, on Saturdays. Okay.
Yeah.
So now we're going to be doing Friday after school / work. What times work for the parties? I know Sunday we'll want to get him home in time to be rested for school Monday. So let's start with Friday drop off. What works Friday, late afternoon, evening?
Yeah, late afternoon Fridays, probably like anytime after about 5 would work for me on Fridays. And then Sundays I'd like to take him to church with me Sundays. So, and my church gets out about noon, 1, so I can always have him back about 3 if that's cool.
Ms.
I think
Redden.
that makes good sense.
Okay. Ms. Redden, what works for you? Let's start with Friday.
I'm a stay-at-home wife, so it's whatever works.
So you work inside the home, we say, because that's about 10 different jobs. So,
Yeah.
okay. So
5 is fine. 5:30.
okay. So we'll say, 5 p.m. Friday, and then having him home between 3 and 4. Does that give you time for dinner and get him back into the swing of your household before bedtime Sunday? Or I don't know what your Sunday schedule is.
I I mean, I think it would be a good idea for him to go to church with Bree. So I would say 3 o'clock just to give him some time to adjust, to eat dinner, and then start, our bedtime stuff.
Okay, so we'll say 5 p.m. Friday to 3 p.m. Sunday. And then the exceptions will be the 2 holiday Mondays we have coming up, Christmas and New Year's. Is there a time, Ms. Redden, that you would want him back Christmas Day, the late afternoon, evening of Christmas Day?
Sorry, I'm going to grab a different phone to look at the calendar so I can make sure.
Okay, so he'll be staying Sunday night, the 24th. So he'll be spending Christmas Eve with Ms. Muldoon.
Okay.
He'll be with her Christmas morning. What time?
Your Honor, we will be up at my mom's house in Cougar for Christmas Eve to spend Christmas morning with my mom. If that's something we could do, if the court will allow me to do with Junior, since I know, because my mom lives an hour away from Vancouver. So it's easier if we just go stay the night up there Christmas Eve with her. And then Christmas morning, my mom will drive me back to Grandma's and we can drop Junior off on the way, if that's something we could do.
Ms. Redden, do you have any concerns about the holiday overnight with Ms. Muldoon at her mom's home?
Which of her siblings will be there?
Believe Ashley and Justine, and then the kids, of course.
Okay. Yeah, if it's just her sisters, that's fine.
Okay. It sounds like there might be a sibling that you prefer the minor not to be around.
Her brother.
Okay.
He is no longer in the state, Your Honor.
Okay. That's why I asked, just to make sure.
Okay. Okay.
Yeah, if she wants to stay with her mom that night, that's fine with me. He'd get to see his cousins. And then, yeah, if on the way back, if they can drop him off so that we can have our Christmas with him.
Okay. Do you want me to set that time, or the two of you can communicate about that while you're en route, or what's the preference?
It's up to Cassandra.
What time do you think you'll be leaving your mom's?
Probably like 11, maybe noon. Just depends on. Probably about noon.
Noon. Yeah. So if we just want to say like 12, between 12 and 1:30 or 1.
That
Yeah.
works.
Okay.
And
then
then
do you want me to do about the same time on New Year's Day, get him back to you January 1st around 1 o'clock?
yeah, let's do that. My birthday is the 31st.
Oh, well, obviously, if Ms. Muldoon and the minor want to celebrate with you, there's no prohibition against that if you all want to meet up on the 31st. So.
Yeah, we can. I mean, me and Bree have been pretty good about working holidays, and Thanksgiving. I asked her what time she was having her family holiday, because we were having ours early. So I actually let Austin go spend Thanksgiving half the day with them. So
Nice.
we seem to be able to communicate and kind of figure out, what each family has planned so that Austin can enjoy both.
Okay. Sounds great. Well, I will get this in an order, but it sounds like the two of you, if you have day of hiccups, can, work it out. There's nothing in my order that would prohibit you all changing the schedule as needed for, family emergencies, travel delays. I know last week with the flooding, the roads were a bit crazy. So, I trust you two can work together.
Yeah.
Okay. All right. Well, thank you both. And we'll see all the parties back January 9th at 10:30 a.m.
Thank
Okay.
you, Your Honor.
This
Thank
is
you. Thank you, Your Honor.
Petitioner Jill Hicks. I still don't see Ms. Hicks. I have Ms. Looney present with video and audio now.
Good morning, Your Honor.
That happens to you. It will work for one docket and then not another.
I was on another docket right before this, so that's probably what messed me up.
Probably, yeah. And Mr. Anagnostou is here. I don't have petitioner, but I know we've kind of just been tracking this. You all still have a trial scheduled in February. We were tracking this because of DNA testing and father incarcerated, I believe. I guess anyone can kind of chime in and tell me what we need to do today, if anything.
I can give an update as to where we're at with genetic testing.
Okay,
At this point, we've served everyone and we do have a hearing scheduled for January 3rd to request that an order for genetic testing be entered. Once that's done, then we would need to get everyone scheduled for their appointments to have the genetic testing. So I can't give a day when that would be completed. It's likely we may not be able to complete the parentage action before the trial date is set. So at that point, the state would just be requesting to reserve as to child support until that was done.
and without petitioner here, I guess I'll note that number one, but Mr. Anagnosto and I guess Ms. Looney and the parties, is this a situation where we think proactively we need to change the trial date now? Get you guys on a new trial assignment for a trial date beyond February 5th, or do you want to keep it for now? We'll set a review after January. Well, that's just the order. So maybe late January, the week before readiness, back on this docket and see what we want to do, or what are your thoughts?
Well, my thoughts, Your Honor, is that the matter can't go forward against my client without genetic testing. I mean, there's been, I guess, an allegation that he's potentially not the father, and that's determinative on whether or not a guardianship action gets entered against him or not. I mean, so it wouldn't make sense to go through a guardianship. I mean, I guess if you wanted to enter orders against the mother, and you'd end up having a reserve as to my client because genetic testing wasn't done yet, and he's not. I mean, there's apparently some allegation that he's not the father.
And Your Honor, it would be my preference that we enter the order against mother who has agreed, reserve on father, let the DNA testing take its course, and if he is determined to be the father, it can be brought back. He is currently incarcerated and will be for a significant period of time, and this child is in need of a guardian who can facilitate all of their regular care. We've been in the emergency guardian phase for an extended period of time. And I think that when we're talking about what this child needs and being able to safely provide for her, that's really where we are. We're coming up on a year in an emergency status. And when the father was out of prison and in the community, there were struggles in getting contact with him or facilitating the DNA then. So I think that this child should not have to continue to wait. We should enter the agreed order with mom, reserved to dad, and let dad bring it forward if he's determined to be the father.
Any party have positions on that? And I'll just note right now what we're dealing with. We did enter the order appointing emergency minor guardian on June 22, 2023. And that did indicate that this emergency order would be in effect until the final hearing is held, which right now we're scheduled for a week of February 5.
I guess I'm opposed to Ms. Day's recommendation in that it potentially prejudices my client. At least there's an allegation somewhere that he's the father, and fighting a petition to set aside a guardianship that's a full guardianship that's been entered, it would be different than appearing on an emergency matter and going forward with that once it's determined whether or not he's the father. I think there's a prejudice of rights if we do follow Ms. Day's recommendation.
Ms. Looney, any position on behalf of the state as it pertains to the child support issue and the genetic testing and how that?
Your Honor, the state would just, Your Honor, the state would just be requesting, if the trial went forward in early February, we would just be requesting to reserve as to child support for both parents, because we would not want to calculate child support as to only one parent. If genetic testing does not show that Mr. Knight is the father, then we would just file a motion regardless to establish support for one or both parents. At this point, we would not have a position as to when trial should happen.
Yeah. Well, and it's my understanding, and certainly if the parties want to brief this and have a different opinion, I'm certainly open to that. But my understanding is if we don't have the outcome of the genetic testing showing that he's the father, he, I mean, essentially wouldn't be a part of any guardianship ruling anyway. Like we've kept him as a pseudo party at this time, and he's been appointed an attorney, but without verifying that he is the father, I'm not sure he's an actual party right now.
And that's historically how the court has handled these types of situations. If they are not identified as the father, they're not a party until they are formally identified. He has not signed a paternity affidavit and paternity has not been established, and he is a non-party at this point. We should enter the agreed, and if he is determined to be the father, that can then be revisited without prejudice. And I think the court can indicate it that way. So there's no harm, no foul against him should he become available by the time DNA is proven one way or the other.
Mr. Anagnostou, do you want any additional time to brief that issue or make argument to the court? I guess I'm inclined to, for now, keep the trial date as is, but if you want more time on that issue, I could set a further court date where, I mean, I guess I'm just thinking through this right now, and I don't want to blindside you without opportunity to argue that issue, but I think Ms. Day's request does seem to make a lot of sense, unless you truly do believe that prejudices your client in some way and want to brief that issue.
I would like the opportunity to look into that issue.
Okay, I think that would be that'd be helpful to the court at any rate. What date should we set for that? I think what I'll call it is pretrial management. Because depending on how I rule on that issue, you all may or may not need the February trial date. And again, I know we're coming into the holidays, so I'm happy to accommodate whatever schedules work for the parties.
That date that we just picked with Miss Day, because she's not available the second, but then I think we went with the 9th.
The 9th, will that work for you?
Yeah. The week after is a week of trial for me, so
Okay.
I prefer not having a hearing.
Okay, and I know that's also the Tuesday after holiday Monday, so I don't know what that looks like. Okay, let's do January 9, 10:30 a.m. We'll call it pretrial management. Again, I'll give the next judicial officer, I can't recall who it is off the top of my head, but a heads up on where I'm thinking we would be going on January 9th. And yeah, anything else right now on this matter?
If I could inquire from Miss Looney, so is genetic testing set up with my client?
No, not yet. We have the hearing on the 3rd for the court to enter the order so that we can do the genetic testing, and then the appointments will be made after that.
What do we need a hearing for? Can we just sign off on an order and get that entered, or?
We can discuss that off the docket. I don't know where we are in the process specifically. I just know that we do have that hearing set.
Because my client he's already indicated to me that he's willing to go through genetic testing.
He does get a copy of the order. He can sign off on that if he wants to do that. We haven't received anything to the best of my knowledge.
Okay. And that's a separate matter. If you want to provide the order to me, I'll see about getting it signed.
I can find that information.
Okay. Yeah, I'll let you all handle that off docket. Thank you both so much. Ms. Day, thank you for your input. We'll see the parties back on January 9th.
Thank you.
All right. Thank you all.